individual webinar session today focuses on privacy and follows a series of other webinars focusing on cybersecurity from the perspective of international peace and security, cybercrime, as well as a webinar session on the technical foundations of this policy debate. The webinar will consist of a presentation of about 30 to 40 minutes, followed by Q&A, but feel free to submit questions during the presentation itself using the Q&A box at the bottom right of your window on your screen. Please note that the webinar is being recorded, and I will be reading your questions out loud during the Q&A afterward. I will not be reading your names, but will be reading your questions. So please be aware that the recordings of the questions and the presentation will be made available publicly later on. Last but not least, just for your information, there are obviously many ways to define cybersecurity. The definition that we are using for this webinar series is a definition developed by the Freedom Online Coalition's Cybersecurity Working Group in Internet Free and Secure. And the working group last fall adopted a definition which starts with a preamble stating international human rights law and international humanitarian law apply online as well as offline. Cybersecurity must protect technological innovation and the exercise of human rights. And it goes on to define cybersecurity as cybersecurity is the preservation through policy, technology, and education of the availability, confidentiality, and integrity of information and its underlying infrastructure so as to preserve the security of persons both online and offline. For those of you who are technologists, you will notice that this definition closely resembles the ISO 27000 standard. And with that, it's now my great pleasure to introduce you all to Andrew Puddephatt, who is also a co-chair of the Civil Society Participation Advisory Board and a recognized international expert on freedom of expression policy and practice with a particular focus on digital policy. Andrew has worked in the field of human rights for over 20 years and has been an expert advisor to numerous international organizations and governments. It's a great pleasure to have Andrew here today with us. He will be leading the presentation for the next 20 to 30 minutes, and then I will be jumping back in for the Q&A and will help Andrew moderating those. So please feel free to submit questions as Andrew is giving his presentation. We will be collecting those, and I will jump back in a few minutes. And with that, handing it over to you, Andrew.
Thanks very much, Tim, and welcome everybody to the last webinar of the series on privacy and cybersecurity. No, I'm unmuted. I'm unmuted. Can I just get, Tim, from you that you can hear me okay?
I can hear you fine.
Okay, thanks. So privacy and in the context of cybersecurity is a pretty large topic. So inevitably what I'm going to do this afternoon in the time I have is be fairly cursory and superficial in my coverage. What I want to do is discuss the meaning of privacy in a cybersecurity and human rights framework, explore how the notion and realization of privacy is changed by the internet, to identify the factors shaping the way that privacy is affected online, and then lastly look at the roles and responsibilities of the different stakeholders, companies, governments, and civil society and users ourselves. So I'll try and do that as briefly as I can, and then obviously we can go into the depth, a bit more detail in response to any questions and further discussion. Privacy, one of the interesting things about privacy is that it has very different meanings in different contexts and different societies. It's not a very well-defined term, even in international law. It's clearly linked to a notion of personal security and to our ability to control our immediate environment, and in particular, what is known or can be known about us. But exact definitions are actually quite elusive, and what's interesting in the case law that we've seen internationally and at national level is that courts have often refused to provide clear definitions of privacy, saying it's neither desirable or possible to actually define exactly what we mean by privacy. Within international law, it's really defined as that no one should be subject to arbitrary or unlawful interference with their privacy, family, home, or correspondence, nor unlawful attacks on their honor and reputation. So in international law, the concept of privacy is also linked to your reputation, which brings up issues of defamation, which is why Contrary to some assumptions made in the last year or two, there are often tensions between free expression rights, my ability to say what I like and access information about someone that I want to, and privacy rights, my right to deny you the right to access information or talk about me in a certain way. So there's a definite tension there and complication between privacy, free expression, access to information. It's something that in the offline world has had a great deal of attention. And privacy as a human right is not unlimited. It can, in international law, be restricted on grounds of national security, public safety, economic well-being, disorder, crime, health, morals, and the protection and rights and freedoms of others. So that gives us a lot of scope to really, if you like, interfere with people's privacy, certainly alleging that we have legitimate grounds in international law to do so. So we need to bear that in mind when we look at the kind of systems that affect privacy that are imposed by governments. I should also say, because it's often misunderstood this, that privacy is not the same as data protection. Data protection are a set of rules designed to address the systematic collection of data about individuals and how that individual is held and used and circulated by so-called designated data controllers. Privacy is broader, more fluid, and it applies to any information about a person about which they may have a reasonable expectation of privacy. So don't assume that if you simply deal with data protection, you've dealt with the totality of privacy. They're not the same. They're closely related and intertwined, but they're not the same concepts. And the meaning of privacy, as I said earlier, has changed and changes depending on context. I think we can safely say that personal integrity lies at the heart of privacy, as it lies at the heart, I think, of most human rights, a sense of integrity and dignity of a human being. But the notion of privacy in a communal village, where you might share a room with 12 people, and the notion of privacy in a modern city are clearly very, very different. And in historical terms, the emergence of generalized private property, particularly single households, has had a profound effect on the way we understand privacy, as has technology. So the modern debate about privacy, the very first paper on the right to privacy was written by Warren and Brandeis in 1890 in the United States, came about because people saw their photographs published in newspapers at the end of the 19th century and objected to their picture appearing publicly. So technology has always had a big impact on the way we see privacy, and there's no exact boundary to the right to privacy. So we should expect that dramatic technological changes like the internet will inevitably reshape dramatically the understandings of privacy, the challenge to privacy, and the way we think of privacy and operate concepts of privacy. And that may explain a long-remarked contrast between what people often say about their privacy and how they behave online, which has appeared to give up any notion of privacy. It may be that the dramatic nature of the technological change is one that we're still adjusting to and still trying to understand. Now, the internet is different because it technically enables the collection of new types of personal information, including biometric data, facial recognition data, etc., etc. It facilitates and, in fact, economically demands the collection and location of personal information. It creates new capacities for government and private actors to access and analyze personal information, and it creates new opportunities for the commercial use of personal data. And it creates new challenges for the regulation of privacy and the governance of privacy, given the transnational nature of the internet and the transnational nature of data flows. And internet services also redefine privacy and the environment very dramatically. So cloud computing, for example, which is where our data is held by third parties in servers in different parts of the world, raises big questions of security, data breaches, and legal ownership. Search engines systematically track and monitor our behavior, raising big issues of privacy. Social networks really depend on company-led exchanges and analyses of data provided by users. That's how they make their money, that's how they survive. And the mobile internet, and increasingly with the next generation of internet users, it will be a mobile internet, access through our mobile phones, ties internet use to geolocated devices, which also carry a whole range of personal identifying information. And finally, with the development of the Internet of Things, which connects all the potential objects in our life together, and a network that can create a complete picture of our lives for other people, which will raise enormous amounts of privacy implications. And finally, of course, governments have created in the recent years an increasing number of digital platforms to provide services online. In fact, many governments, for cost reasons, are moving to digital platforms and the provision of services. And this is very cost effective. If you take figures published in the United Kingdom, the average tax return online costs about 67 pence. A manually filled in internet tax return, sent and filed and uploaded centrally, will cost something like 15 to 18 pounds. So the saving is 25 to 30 times by having e-services. So we should expect to see the move to e-services accelerating in governments across the world. And some governments have begun to develop designated e-identities, countries like Estonia, that allow us to access a range of services from banking to voting to health monitoring through that personal e-identifier. And with the sheer volume of data that governments are directly collecting to provide those services, it's obviously inconceivable that governments won't seek to access that data at times for other purposes. So we have a real issue arising out of the government's own collection of data, done with our consent, about how to balance the provision of e-services with security and personal privacy. And of course, governments have become increasingly concerned as the internet's become ubiquitous with security issues online. Now, these are for both legitimate reasons, the prevention of crime, child pornography, terrorist activities and terrorist networks, and for illegitimate reasons, a concern to suppress political dissent, political mobilization, and opposition to the government. And what the Snowden revelation showed us in relation to a selective group of governments is the likelihood that all governments are attempting to access information about us online. And there are really 5 concerns about government surveillance. Firstly, the scope of surveillance. Who are the targets? How big is the net? What is the nature of the people that they're looking for online? And how are they doing it? Secondly, whether the legal framework governing that surveillance is adequate to generally protect people's privacy in an online world, because most of these legal frameworks developed in relation to offline databases. Thirdly, a particular concern is the use of mass metadata searches algorithmically, which are often excluded from legal accountability because the algorithms that analyze our metadata are not treated as agents in legal terms. And one of the interesting features of the outcome statement by the chair statement by the Dutch government is it seems to recognize for the first time that I've seen in an official document that algorithms can be agents. That's something that I think is a very important legal and normative development. A fourth concern is the weakness of the oversight bodies, often an absence of technical competence. There are very few computer engineers who sit on regulatory bodies governing surveillance, so many of the lawyers and eminent people who sit on them may not understand technically exactly what's going on. And finally, an absence of legislative competence. The fact is that internet policy debates tend to be inhabited by public officials, by companies, and by civil society activists, academics, technologists, not by legislators. Legislators are one of the great absences from the internet policy discussion. So when they come to legislate, they're often, I think, fairly clueless, if I'm put it slightly impolitely, about the implications of the laws they're passing. Now, we should remember that the internet is built and operated by the private sector. We often think of it as a public utility. We may think of it as a commons, as a street down which we walk. It's actually a shopping mall controlled by private companies. And the provision of some of the most popular and lucrative internet services are based on a business model that's essentially based on advertising. And what we do when we engage in that business model is we trade or cede our privacy in exchange for free services. We give them our personal information and we get the service for free. And some such service models either directly depend upon exposing private information. This is what Facebook does. It takes our private information and shares it with people. Obviously, with our consent notionally, if we choose to impose those privacy settings. But it's information that we would have historically always regarded as private. That's now in the public domain. Or the companies intrude upon our privacy to create efficiencies. So, for example, they develop tools that optimize searches based on tracking our user preferences. Now, that actually does make a more effective search model. If you try search engines that don't use those tracking of preferences, they're often less effective than the traditional search engines most of us rely on, like Google, because they're not tracking our preferences, they're not trying to understand us, they're not monitoring our behavior, so they tend to give us a slightly more random selection. So there's a double-edged sword to all of this. We get something, but we give something in that process. And that's why I think there's generally been little public pressure and certainly no business incentive to change that fundamental business model. And the data protection model that's applied, which is where we give our informed consent to the service provider by ticking a box that says terms of service, is very complicated by the very different range of applications we may log on to, all of them with very different terms of service. The complexity of those terms of service, they could run to 40 pages and actually often give the power to the service provider to change those terms of service arbitrarily without consulting us again, and apparent public indifference, where all the evidence is that almost no one, I hope someone out there does, but most people don't read those terms of service before they click on accepting them. They simply say, click the box, and away we go. And backing that up is really the economic importance of the internet. The internet, and this will be a feature of the Dutch conference, there's a massive influence on the economic importance of the internet, which is increasing pressures for data sharing and particularly cross-border transfers of data. So I think one of our strongest arguments is to say for a business environment to develop that depends on people feeling secure and which trades in categories of information such as finance and health that need to have guaranteed confidentiality, cybersecurity, guaranteed security for our privacy and our data is actually essential to the development of an internet-based economy. So we have a human rights argument we can use, but we also, I think, importantly have an economic argument around the take-up of internet services and economic development. Let me just give you a bit of background on that, just on the cross-border transfers, which are the things that are particularly difficult to regulate and which particularly expose people to, for example, surveillance by government. Cross-border transfers of personal data are now very common in utility provision, financial services, education, e-commerce, and health research. And some figures from McKinsey said that cross-border internet traffic grew 18-fold between 2005 and 2012. We're seeing a growth in digital trade and new technologies such as 3D printing that could see global flows of capital, data, goods and services triple from the $26 trillion worth in 2012 to an estimated $85 trillion worth by 2025. And many governments around the world see the growth of the internet economy, the growth of data transfers, the development of trade agreements such as TTP and TTIP, which allow the transfer of these great data sets as crucial to their economic development. I've had foreign ministers in progressive left governments in Europe saying to me that the last hope for the European economy is the internet and the provision of data services online. So a key question for us is how to protect privacy and individual liberties while enabling the free flow of personal data and maintaining the security of that personal data. That seems to me the really key challenge that we face in the next 5 to 10 years. Now, privacy, as you all know, human rights, according to the Human Rights Council, the human rights that we have offline should be the human rights we have online. What does that mean in practice if we try and take a concept like privacy, which actually offline has very, very different meanings and challenges to privacy online? Well, obviously, we need to start by understanding what is new about the internet environment and how to understand and tackle those privacy challenges. Bear in mind, let's not just talk about what we have now, which itself is a considerable and formidable challenge, but let's look forward to the next generation of technological innovation that's coming in the next 4 to 5 years, the Internet of Things, wearable technology, artificial intelligence and robotics, 3D printing, all of which are critical to society, to economic growth, but all of which will provide further challenges to and reshapings of notions of privacy. Now, all of those technologies, I believe, will depend upon strong security, both technically in the forms of encryption and anonymization, and normatively in the shape of legal rules governing access to and use of personal information and personal data. But this is not going to be a straightforward challenge. And I think we have two big issues to consider. Firstly, the private sector and the implications of developments in the private sector and where technologies and markets are leading. And if you were to go to, say, the GSMA conference in Barcelona, as I did this year, with 85,000 corporate members, you see incredible excitement about the next range of technological development, particularly the mobile internet, but almost no consideration of thought to the human rights, privacy, or public interest implications of that technology. And the second area is the use of personal data by governments, not just the surveillance issues we've discussed heavily post-Snowden revelations, but the wider recasting of citizen-government relationships digitally in the areas of tax, in the areas of health, in the areas of personal finance, in the areas of service provision. And how do we produce our ideas on balancing the problems of tackling crime and terrorism, which are real and genuine? We can't ignore them. We can't go to governments and be taken seriously if we say they simply don't matter. How can we tackle that and balance them against the need for privacy, anonymized identities, and so on? So I think the privacy agenda for us, at the heart of it, as I said, lies a sense of personal integrity and dignity, whatever the social and technical context. And at the core of that, I believe, is a sense of ownership and control. Do we own and control the information that exists about us, which is the basis of data protection systems, and what can be known about us? Current business models require us to hand over ownership of our data to companies in exchange for benefits, and the use of that data is usually loosely regulated, if at all. Can we change that? Can we think of a different business model? Can we control the way those business models operate to create a greater sense of ownership of our own data and information? Government access to data, however intrusive, compared to companies, at least operates in most democracies in some kind of legal framework. So how can we strengthen those legal frameworks to protect privacy online in the broadest sense? I think that creates a certain agenda. And for governments, that means governments should commit as a policy goal to ensuring user security and privacy as a core part of their cybersecurity agenda. They should commit to supporting free expression, being aware of the need to balance both rights. They should understand security and cybersecurity not just as a state issue and a concern for states, but as embracing user interests. The user should be at the heart of the notion of cybersecurity. Governments should be far more transparent than they are about the rationale and the scope of surveillance and other measures that violate privacy. They should ensure that rules governing surveillance and privacy are grounded in law, consistent with international norms, and subject to supervision by independent courts. And they should make sure that regulatory bodies are equipped to do the job they need to do by having the appropriate technical skills on board. Companies, in turn, should practice greater transparency about their own data management practices. They should provide accessible and reasonable terms of service. By reasonable, I mean they should not have terms of service which allow them to change it at their timing without further consultation with us. In the offline world, if you change the terms of service, if you're a data controller, you have to consult people again. Internet companies should be made to do the same. We should explore and encourage a shift of business models to one where users control their data, users control their information, and we give specific permissions to those people who we wish to use and exchange our data by their own purpose. So the presumption should no longer be we give our data and it's up to them and they consult us about it, but we permanently own our own data and we license other people to use it. And obviously companies should do, as some are beginning to do, publish details about government requests for their data. And finally, civil society, we've got a role too. We need to represent consumers and consumer interests. We need to bring in concerns from excluded and marginalized groups. We need to provide innovative ideas and policy options in the debate, not just shout and scream from the outside, but actually contribute really concrete ideas as to how things can be improved. And we need to champion a public interest and a human rights approach to privacy policies online. Now, can we have a comprehensive overarching view of privacy globally? Well, 10 years ago, the UN's Human Rights Law Commission concluded that no homogeneous hierarchical meta-system is realistically available within the international legal order to resolve detailed differences among separate spheres. And this would have to be left to the realm of practice. This means we probably won't tackle global privacy policy in one place through one instrument. We have to practice privacy protection in a range of different forums. These would include policy forums, the International Conference on Data Protection, Privacy Commissioner discussions, Internet governance forums. Alongside those specific policy forums, we need to be looking at UN normative standard bodies, such as the UNGA with its resolutions on privacy. We need to be looking at specific recommendations, like the OECD guidelines on the protection of privacy and transborder flows of personal data, and encouraging non-OECD countries to develop similar standards and models. We need to look to the work of UN special procedures. The UN Human Rights Commissioner's recent report's a good example, and now we have a new privacy special rapporteur. We need to look at the work of technical bodies, the Internet Engineering Task Force, and the improvement of encryption standards. We need to look to regional and national courts, looking at some of the ECHR generic privacy cases and some of the specific cases in national courts, such as the Yahoo judgment in Paris or the Louis Fareux judgment in the New York State Court. So there are a range of different forums in which our privacy will have to be argued out. The practice of privacy, I think, means, in summary, promoting business models that provide for user data ownership, look for consensus-based consumer-friendly norms that incorporate international standards for data protection and internet security across boundaries. We need to be encouraged transnational co-regulatory initiatives, promote voluntary cooperation among stakeholders. We need to set appropriate regional and multilateral standards for protection of privacy online in the different international and national bodies. We need to campaign for appropriate national regulation. And particularly, I want to emphasize this, we need to anticipate future privacy challenges, not just the ones we have, but the ones that are to come in the future. That's my webinar, and I'm now open for discussion and questions. Over to you, Tim, as moderator.
Thanks a lot, Andrew. This was excellent. Many thanks. And we have 3 questions at this point, which I will read out loud one by one. I'll start with the first one. And I also encourage the participants to submit additional questions right now using the Q&A form at the bottom right corner of your screen. The first question that I received is, can the creators or implementers of an algorithm be held accountable for breaches of privacy in our current system?
I'm going to answer a number of things. That's an interesting question. At the moment, in most legal systems that I'm aware of, and I don't claim to have looked at all of the internet laws around the world, but the ones that I'm aware of, the algorithms themselves are not agents. And if the algorithms are not regarded as agents, I think it becomes questionable whether you could take a case against the creator of the algorithm. And in the case of an algorithm that's doing, say, a metadata search, one of the other issues is that most of the legal regimes require you to demonstrate damage before they respond with a remedy. And one of the difficulties you would have with a broad metadata search, depending on what that metadata search is used for, let's say it's being used to scan everyone's data to identify a particular set of criminal activities within that, which are then followed up by individual surveillance, it might be difficult for you to A, know you've been subject to that metadata search, and B, prove damage. So there's quite a number of legal obstacles. I think the starting point is for national regulation, which is, I think, where the ground rules, if you like, where this starts, to treat algorithms as agents. and to recognize that a metadata search needs to be governed as part of the surveillance system, whereas many countries will say, we don't undertake mass surveillance, we do mass metadata searches algorithmically, but we're not looking at your individual data. It's only when we get to look at individual data with human agents that that becomes a surveillance system governed by law. So that's one of the big issues that I hope will surface at the Dutch conference.
Great, thank you, Andrew. The next question is, what are the means of holding the private sector accountable for breaches of privacy?
Well, obviously, depending on the private sector is very different. So a telecoms infrastructure provider would have terms of service with you, and an internet service provider would have terms of service with you. If we take the obvious ones people are most likely thinking of, the Facebook, the Google, and so on, which aroused a lot of controversy during the Snowden revelations, they're mostly based in Southern California, or they're mostly based in Palo Alto in Northern California. They are governed by the laws of California, and so your redress would be to go to the courts in California and say, they have breached my terms of service. You actually have two arguments. One is you could say the terms of service are egregious and a violation of common law norms and values, and in a system like the United States, which is like the UK, a common, and like many other countries, a common law system, there's a certain test of reasonableness. So, for example, I think to require you to sign a terms of service which gives the unilateral right to the service provider to change that terms of service as and when they choose might be regarded by many courts as egregious if that challenge was taken. So one option would be to take a test case in California on those grounds, but the other grounds is if you sign the terms of service which hand over your data to the company, then you need to find out what is your beef. If they violated the terms of service very clearly by using your data in a way they didn't say they would, and they're not obliged to in terms of the laws of their own country, remembering that there are acceptable privacy violations on grounds of national security, and there'll be national security provisions governing those companies in the United States, then, I mean, you've really got to find your case. So you may have a case, but you've got to pass a number of tests, that it does breach the terms of service, and that it's in excess of the laws of the land of where that company is registered, in this case, the United States. And there you're up against the Patriot Act and national security laws in the US, which I think give the government a reasonable degree of latitude. Not as much as other countries, but quite a lot of latitude to interfere with people's.
Thank you, Andrew. For the participants, if you have any follow-up question to anything that Andrew just was explaining, or if anything was unclear, feel free to ask follow-up questions. And I'd suggest just write follow-up question at the beginning so I know what it's relating to, and then I will make sure to include them. The next question for you, Andrew, is from a grassroots level, in terms of changing public opinion, how do we address the fact that many people don't feel that privacy is a problem when using the internet?
Yeah, I mean, that's the really big question, because what I think we don't yet know is whether the nature of the environment of the internet, which does involve putting on display and sharing and exchanging information which traditionally offline we wouldn't normally have done. I mean, you may have seen the famous, the interview with Edward Snowden, I think a couple of days ago with John Oliver, where they talked about the exchange of dick pictures and the fact that governments can look at explicit pictures you posted online or sent to somebody. I mean, the really extraordinary thing for someone of my generation is people would choose to take those pictures and share them in the first place with anyone. So I think there is possibly a societal change taking place on some scale, just as there was in previous eras of history with other technological and social change, which means that people will require less privacy about some aspects of their life. I think the thing to focus on for me is the core elements of what is it that you would always never want to share. I think, for example, if we want to use banking services, if you want to use health services, you would always want to restrict access to that information to a designated number of users. I'm happy for my bank to have access to my personal details, and I accept that that means a number of employees of that bank have access to those personal details. I don't particularly want other companies that I may buy things from online to have direct access to my bank account for the obvious reason. If I am having wearable health technology, I want to use that technology to share my health data with the necessary health professionals. I don't particularly want to share it with the rest of the world because it's those health professionals who can help me. So I think we need to, if you like, explain to people in much more detail the nature of the transactions they're undertaking. And I think we need to encourage, and this is something we could do as public interest groups, the development of business models like search engines that don't require the harvesting of data, but which can prove themselves to be more effective or as effective as those that do track our preferences and retain that data online for purposes of sale. So I think partly it's a question of framing. If you look at all the surveys, people, if they're asked the question one way, say yes, they do value their personal privacy. If you ask it another way, they don't seem to value their personal privacy. So I think there are basically two answers to your question. One is I would focus much more down on the nature of the transactions people are undertaking. And I think personally, the social networking has gone so far that I think it'd be very difficult to persuade a generation of young people not to share the social data that they share online. I just think that kind of development is out there and it's happening. But when it comes to some of the key economic drivers of the internet, and the economy will be a very powerful force for change around financial data, government digital data, health data, and so on. There, I think we have a strong argument that encryption and privacy and security is essential to the economic functioning of the internet, and therefore there should be high levels of protection for that kind of information and data, and people should value it. And I think that's the key thing, is making people conscious of what they're doing. I think far too often people turn on a computer and it feels like a natural environment. One of the great gifts that Apple gave us, and I speak as someone who was programming computers in the days of Fortran and COBOL, for the older folk out there among you, is computers were very unfriendly to people. You just typed in machine code and that was the exchange. What Windows did and what Apple did with their user interface is take a technical engineered environment and turn it into something quite natural, often with a natural, beautiful landscape. You turn it on and your background browser is some beautiful field. So you feel you're in nature. Actually, you're in the middle of a piece of engineering. We need to convey to people, much more strongly than we do from schools on, that you're in a highly engineered private sector environment, not in a natural public landscape. That's the big shift that I think generationally we need to try and address. Tim, any more questions?
Yes. Right now I have 4 more on my list, and I'm sure there will be more following. The next one is related to what you just said, and the question is, do you think that by agreeing to terms and references to use a service, people are truly understanding what they're agreeing to? Does this really make the agreement consensual? And how could the use of data be made more transparent? Andrew, did you hear me?
Sorry, I didn't unmute. Yeah, sorry, I'll come back. Yeah, your question is absolutely right. People don't understand the terms of service, and companies know that they don't understand the terms of service. As I was saying to my muted mic 30 seconds ago, I sat through a talk by the Vice President of Facebook who cheerfully said, we know nobody reads our terms of service. We know that's not how they judge their experience of Facebook. They judge their experience of Facebook by their interaction with Facebook, not by the terms of service they've signed. So I think there's a real question mark about the validity and reasonableness of those terms of service. And I think they should be simpler, more accessible, and that's something that governments could and should insist on, in my opinion. and the government who, in the jurisdiction in which companies operate, should say your terms of service should be much more transparent. Whether you can challenge those terms of service, as I said, I'm not a trained lawyer. I'm someone who's familiar with common law principles. I know a mobile phone company in Britain set up free wireless access in Trafalgar Square, one of the main squares in the centre of our city. And about 8 pages into the terms of service, you agreed to give your firstborn child to the company. And most people clicked on the terms of service and agreed to give their firstborn child. Now, most lawyers I spoke to said that would never have been honoured in court. That is such an egregious use of a terms of service, such an unreasonable requirement, that the courts would have ruled it unconstitutional or unlawful contract, even though you signed it. So I think the question is, are those terms of service so egregious and so disadvantageous to people that it's wrong to put them in such complex detail they can't be accessed? That's a question I think you would have to test in court. And I don't know if that's been tested in the California court, because that's where you'd have to go and test it, because that's where most of these big service companies are based. Tim, over to you.
Thank you. I'm going to combine 2 questions that are very similar. And the question is, well, what do you do in a country where legislative and legal provisions do not exist, or where the government has strong secret laws?
Yeah, I think then the key demand, obviously, is, as it would be in relation to any other human right, to establish the rule of law, clear legal provisions which are transparent and understandable and accessible to people, and supervision of those laws by independent courts. If you don't have that provision, and that becomes a long-term problem, then clearly there's something of a devil's choice in front of you. You can use international service models, such as those provided by US companies, which will give you protection from your national government, that give access to your data to the US government and friendly governments and those US companies. It's a choice for you as to whether that, in the end, gives you an advantage over not having access to those services at all, or using state servers and state services which will be governed by no principles or rules whatsoever. I think the experience has been that in repressive countries, people, as we've seen in Egypt and other countries, people have used Facebook and other services of that kind because they provide advantages to that domestic repressive systems of communication simply don't do. But obviously none of this is a satisfactory substitute for the pursuit of a legal system that incorporates international human rights norms in domestic law and provides independently laws passed by an independent legislator and supervised by independent courts. And then it's no longer just a privacy issue, because I think in circumstances you're describing, it's an issue for free expression, for the right to association, for the right to fair trial, and for every other gamut of human rights.
Thanks, Andrew. The next question focuses on Europe, and the question is, how do the recent EU laws on data retention and privacy change the current status quo of internet business models? And with the possible advent of TTIP, would you expect these to be watered down further, degrading user privacy?
Tim, could you you just broke up on the first sentence. Could you just repeat that for me, please?
Sure. The next question focuses on Europe, and the question is, how do the recent EU laws on data retention and privacy change the current status quo of internet business models? And with the possible advent of TTIP, would you expect these to be watered down further, degrading user privacy?
Could you ask the questioner whether they mean the proposed directives, the right to be forgotten ruling, the proposals from the Commission, or actual laws by individual European states?
Yes, the person who asked this, please provide more details in the Q&A box. And in the meantime, I will ask you the next question on my list, which is, do you think data portability, exportability, in an open format should be a legal requirement?
it would be an interesting position to put. I don't know, in terms of the kind of demands we could make to governments, that it would be the thing that we would find most easy to insist upon or push. I think it would be a very interesting development, and I'd love to see that aired within the framework of the Dutch conference, for example, so we can get a reaction from governments and business. I think it's an interesting idea, and I think we should be thinking about a whole range of different models and different ideas. Whether you could insist upon one model legally and constitutionally across the world, I'm doubtful, but I think let's give it a go. It's an argument worth running.
The next question is a follow-up.
Can we go back to the first question?
Sure. I'm actually still waiting for the additional detail. So okay. Let me move on to the next question that I have on my list. It's a follow-up question. How do you deal with the problem, to the comment you made earlier about people's awareness? And the follow-up question is, how do you deal with the problem of people who may not be aware of aspects of their personal privacy? For example, location data may represent sensitive information depending on the context, but not always.
In a way, this is, I think, a question for all of us. You know, how do we as civil society actors concerned with privacy raise these issues in the various environments in which we work? I mean, I think one of the areas is clearly the transparency of what's happening. So if I look at my Apple iPhone, if I download a free application that's a torch, if I read those terms of service, it gives access to the person providing that application or to all the personal data on my phone and my geolocation data. It's a torch. It doesn't need to know any of that for the functionality of the application, but it does so because that company can then sell that information through a range of other companies onto the London or the US ad markets, which are the two biggest ad markets in the world. So people aren't aware, I think, when they sign on applications that this is what's happening. So one thing I think we need to say is, if the service is free, you are the product. And we need to say this time and time again. Every time you download a free app, there will be a price you're paying for that, which is your personal data. And you're giving, most certainly in the terms of reference, someone the right to access that personal data, even if the functionality of the app doesn't require it. Now, you could push for a legislation that said you can't demand access to data that isn't necessary for the functionality of the app. That would require everybody to pay for every app they download. It would require, and this is the challenge for all of us, and my challenge, I guess, to all of you on the call, if you were asked to pay for search, and if you were asked to pay, I don't know what, 1 cent, 1 penny, 1/100th of a euro for every page you access, or if you had to pay another $30, $40, $50, $60, $70 a month, pounds or euros or whatever currency you work in, to access internet services alongside the connectivity that you're buying, would you be happy to do that if what you got was your personal privacy? That's the question for all of us. I think if we can answer that question honestly and say, yeah, we're willing to pay for those services, then we can push and promote the notion of paying for services rather than giving our personal data. The other model I'm interested in exploring is that I retain ownership of my data, but I choose, because I have the right to do so, to give Google the permission to share and sell that personal data once I give it to them. So I go online for a search. I don't mind Google having my data and tracking my search preferences. So I license them to use it, but I have the power to recall that license at any time. And I have the power to say to Google, I don't mind you selling this to companies that sell shirts or motor cars or watches, but I don't want you selling this to companies who sell health insurance or financial services, so that I can specify the restrictions on the use of my data. I'd be very interested in a business model that emerged that was based on me owning my data, but licensing others to use it. But all of this requires, in a private sector world, a private sector company or a not-for-profit organization to start developing those business models and making them available. And as we know from the history of the internet, to get to the point of having an effective business model which is sustainable requires enormous colossal investment. And I think I read recently that Google got to sales of 23 billion before it started making money. Now, it's very hard to launch not-for-profit or other alternative business ventures without colossal amounts of public investment or private investment and get to the point you've got a sustainable model based on a different way of doing things. So these are the kind of challenges that I think we're facing. But let's at least raise the issues and different business models as an alternative to the harvesting of our personal data. At the very least, I'd like to see that on the agenda for a business and economic discussion. Tim.
Great. You actually just answered the next question, which was, must the business model be based on sharing of personal information? So we have 6 minutes left. So a last call for any questions you might have relating to this webinar or any of the previous ones that we've had. Then I have 2 more questions on my list. The next one for you, Andrew, is there big data for social change? Some civil society groups in my country gave up privacy and started to think how to use big data for legitimate purpose. Does it work?
I think that's a great question. I think it could work. One of the things that I was interested in doing was harvesting big data to monitor human rights evaluations in real time, rather than relying on existing mechanisms of reporting, which often depend on eyewitnesses or testimony that maybe comes from one person that's not always regarded as reliable. And I think in the vast array of big data, there's a lot of information that could be gleaned and used for progressive social purposes, suitably anonymized, obviously. The trouble is, I had a discussion, I went and had a discussion with Google about this, saying, would you be willing to share some of the big data that you're harvesting with an algorithm that just looks at evidence of or indications of human rights violations? And the response I got was, we don't harvest big data. And I said, come on, we all know you're harvesting big data, that's how you're making money. He said, no, we don't do it. That's not what we do. So I think at the moment, big data, the oil of the 21st century, as Davos called it, is in the hands of private companies. And we would need to be, wouldn't have a strong argument, or would need government support and backing to access that big data for socially progressive purposes. Again, I think it's a very interesting question. I think we should, one of the questions I'd love to see raised in the difference, whether companies and governments would be open to that kind of discussion about the modalities and how it could be anonymized and people's security protected in doing. I think it's a great idea and one that we should definitely explore. Tim.
Thanks, Andrew. And the last question on my list right now is the one I mentioned earlier. I have not received more details, so I'll just pose it again as it was posed initially. The question is, how do the recent EU laws on data retention and privacy change the current status quo of internet business models? With the possible advent of TTIP, would you expect these to be watered down further, degrading user privacy?
So let's assume that all the kind of data protection provisions the EU wants to pass go through, which is not necessarily what will happen, given it requires the consent of all member states. It's very easy in Europe to pick off a member state. But let's say that does happen, and you add that to rulings like the right to be forgotten. You obviously have a privacy system that's very different to, say, that in the US and many other parts of the world. In my own opinion, the likely impact of that would be additional costs for the very large service providers, but costs that, if the European market is big enough and powerful enough, and with 400 million users it probably is, that they're willing to absorb. The difficulty will be for smaller providers, smaller ISPs, who have to cope with a much more difficult regime in terms of providing alternatives. So one of the great paradoxes about data localization, for example, the requirement that data is stored in specific countries in order for a service provider to operate, is the large wealthy companies. I mean, Google, a market cap of 330 billion. If they want to do it, they can do it. If you have a new entry internet service provider from, say, Argentina or Ghana or Pakistan, their ability to cope with EU data protection law is going to be much more restricted. So it could make a difference to the protections we have as at a user level. I think it's likely to entrench, paradoxically, the monopoly power of the large providers. So none of these things come with unqualified benefits. They all have upsides and downsides that we need to think about when we put forward our policy solutions, which is why I think as civil society, in a closing remark, we need to go into these discussions and into the cybersecurity forum with real information, real data, and real concrete ideas to float, rather than just generalized, fairly abstract demands or wishes that life were different. The way we'll shift an impact on this is by really getting to the core of the economic, technical, as well as human rights and public interest arguments, and really make our voices count in that. And that's going to take the kind of research that we've been doing in the last few weeks to really get over. And obviously the pre-event, the pre-training event for those attending it, I think becomes really critical for those of us who want to intervene in those discussions. Tim.
Excellent. Thanks a lot, Andrew. This was an excellent webinar and a perfect way to conclude the series overall. As you said, we look forward to seeing hopefully many of you in The Hague next week. If you are interested in any of the recordings of the previous webinars, please go to the GCCS website, where you will find the recordings as well as the PowerPoint presentations of the previous ones. Also, this is the last webinar of this series, but we also would like to improve and potentially use this model for future webinar series. So please do take a moment when you sign off to fill out the survey that will automatically pop up in on your screen, so that we can get your feedback on how to improve this webinar moving forward. We've done this with every single webinar so far and have gotten some great comments and feedback that we will take with us moving forward. And with that, thanks again to you, Andrew, for leading today's webinar, and for all of you for having joined us today and previously. And I look forward to hopefully seeing many of you next week.
Thanks very much for joining me, and do get in touch. Aditi's sending my contact details around if you want to carry on the conversation further. And see those of you who can make it next week, I'll see you then. Thanks, Tim.
Thanks, Andrew. Goodbye, everybody.
Bye, everyone.